On the receiving end of Sessions's request is U.S. District Court Judge Dolly M, whose record in the Central District of California includes upholding the Flores Agreement against previous attempts to circumvent it. In fact, it was G who set the legal precedent stands between the Trump administration and family detention, ruling in a 2015 decision against the Obama administration that all immigrant children, not just those who entered the country unaccompanied, are protected under Flores. G found that the heavily secured family detention centers, which were run by private prison contractors, violated the Flores Agreement's requirements that minors be placed in the least restrictive settings possible and in facilities are licensed by the state to care for children. In her ruling, G accused officials of ignoring the unambiguous terms of the Flores Agreement and described the administration's claim that family detention was necessary to deter illegal border crossing, an argument echoed by Sessions in his motion Thursday as unpersuasive and dubious. She ordered that children and their mothers be released from both facilities immediately. G has continued to weigh in on immigration-related cases under the Trump administration. In the latest episode of News Pulse News' Skullduggery podcast, former Homeland Security Secretary Jeh Johnson, who was one of the architects of the Obama administration's controversial family detention policy, said he could not predict how G would respond to Sessions's motion. He noted, however, that Trump's executive order effectively acknowledges that the Flores Agreement is still the law, and that it must be modified or suspended to permit the detention of entire families. But the administration preferred to put the onus to act on Congress. In a statement released alongside Sessions' court filing Thursday, a Justice Department spokesman said, irrespective of the court's decision in Flores, it is incumbent for Congress to finally act to keep families together, end catch and release, and create the foundation for an immigration system that serves the national interest. President Trump took decisive action to address the immediate issue of detaining families together for as long he can legally do so under Flores, and now the onus is on Congress to pass the necessary legislative fix, said R.J. Howman, Government Relations Director at the Federation for American Immigration Reform, or FAIR, a pressure group for immigration limits. Unless Congress acts, the government can only detain families together for 20 days, then we're back to square one. This administration is setting itself up for yet another loss in federal court, said Jeremy McKinney, a North Carolina-based immigration attorney and member of the American Immigration Lawyers Association. The decision does not take away the government's ability to exercise its discretion. Rather, it provides the contours for detention practices amounting to an abuse of discretion. McKinney said that families can be held together in certain circumstances, if it is based on an individualized analysis of the child's circumstances and family detention is in the best interests of the child. However, he predicted that any attempts to implement mass family detention as a means of deterrence would be rejected once again. These are human beings we are talking about, and they deserve better, he said. We anticipate the courts will agree.